well. All right, so I do need to take a couple of cases out of turn based on medical reasons and or charges. That being said, I also need to take cases out of turn because I have attorneys here who need to be in other courtrooms. I do that as a courtesy so that they can be in other courtrooms because I have attorneys who are permanently assigned to my courtroom versus attorneys who are not permanently assigned to my courtroom. I'm doing it as a courtesy. Please do not think I'm doing it for any other reason. I'm not going to touch out of county holds, out of state holds, violations of probations on signed warrants, or KPSs for the most part. Please note that these proceedings are not only recorded, but live streamed on YouTube. That being said, that is why the interruptions need to be to a minimum. If you interrupt these court proceedings, whether in person or by Zoom bombing, you could be ejected from these proceedings without warning. Let's start with our out of turns at main jail. They asked that we take somebody, actually, we don't have Spanish interpreters now, so let's go over to Conti facility. Is Conti not up? Okay. Oh, there we are. All right. So who's the first person that we have here at Conti?
Mr. Hernandez.
All right. So this is Mr. Hernandez on page 25 of the regular docket. All right. It looks like it's a change of charge. Mr. Linder, I'll turn to you first. I do find probable cause for harassed victim and witness informant in second-degree felony case of firearm by felon. First, you, sir.
One moment now.
For which?
Your Honor.
Yes, sir.
On the firearm offense, I really have no basis to ask for the court to modify the bond. It's really a technical matter. However, on the tampering or harassing charge, I would ask that the court consider a bond increase from 1,000 to 3,500, Your Honor. It was improperly booked as tampering in a misdemeanor proceeding, making it a third-degree felony. It's actually tampering with the witness or victim in looks like it's been filed as a second-degree felony, Your Honor, the aggravated battery, which it's being listed as a second-degree felony, Your Honor, but my understanding of the statute is tampering in any felony offense raises it to the next level, which would make that a first-degree felony, Your Honor.
Okay, thank you, Mr. Porter.
Judge, I was just going to ask if the court would leave the bonds as is. He has other no bond holds that are holding him in at this time, and he also the bonds without these two charges is at $8,100, which I'm not sure that he would be able to afford. So we would just ask the bonds be left as is. Or as was.
Thank you. I see that it was booked under tampering and misdemeanor proceedings, so it's been correctly now charged as tampering and secondary felony, which makes it a first-degree felony. So I am going to do that bond increase because the charges have been upgraded. So it'll be set at $3,500 on the tampering charge. I'll reinstate the $1,000 on the firearm by felon. Sir, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes.
And as you were previously advised by Judge Murphy at first appearance, you shall surrender all firearms, weapons, or ammunition within 24 hours of your release to local law enforcement. Do you understand?
Understood.
All right. And you cannot have any contact with the listed witness, victim, direct, or indirect. Do you understand?
Yes.
That means no phone calls, text messages, emails, letters, having a family member or friend send a message to the listed victim or witness, or any other means of communication that I have not set. Do you understand?
Yes.
All right, and your office has already been provisionally appointed. Anything else in Mr. Hernandez's case?
No, Judge.
All right, good luck to you, sir. All right, so what else do we have at our Conti facility?
We have Mr. Lund, right?
Mr. Lund, okay, Mr. Lund, good morning, sir. This is a 3040 on the FMN docket. Mr. Linder, has the state filed charges?
Not at this time, Judge. Mr. Lund is entitled to an ROR on this charge.
All right, thank you. Mr. Forbear, do you need his phone number? You have it? Okay. All right, Mr. Lund, the state has not filed charges against you yet. That does not mean that they still cannot file charges. But for now, because they have not filed charges within a specified statutory period, you are entitled to release on your own recognizance. That means you're going to get out today. Please be in touch with your assigned public defender and or look on the clerk system to see whether or if the state files charges. Good luck to you, Mr. Lund.
Thank you, ma'am.
Okay, and I will delete the pretrial conditions as well. Guys, if you could delete the pretrial GPS because he is just a straight ROR.
All right, boy, keep that up.
All right, so who else do we have at Conti? Sir, good morning. What's your name?
Christopher Washington.
All right, this is Mr. Washington on this second look docket. It's $100 KPS. Mr. Linder, does the state have an offer just to resolve?
Documented offer from the state judge is a withhold and court cost. I'm not showing any prior DWSs.
Okay, thank you. Mr. Farber, do you need a moment to speak to him or do you want to ask him on the screen?
No, Your Honor, I already spoke to him. He wishes to try to resolve it, so he would accept that.
All right, thank you. Mr. Washington, please raise your right hand for me, sir. Do you swear or testify to the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you. You can put your hand down and state your name for the record.
Christopher Washington.
All right, Mr. Washington, it's my understanding you wish to resolve your driving with suspended license case today, correct?
Yes, ma'am.
And do you understand the charge against you?
Yes, ma'am.
Do you understand everything that's happened here today?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of alcohol or drugs, sir?
No, ma'am.
Do you need more time to speak to your attorney?
No, ma'am.
Do you understand you have a right to go to trial, but you're forever giving that up by accepting the state's offer?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness, sir?
No, ma'am.
I'm not asking if you're a United States citizen. I just have to advise everybody that comes before me. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings, sir?
Yes, ma'am.
And how do you wish to plead, guilty or no contest?
No contest.
All right, sir, I accept your no contest plea is freely, voluntarily, knowingly given. I find there's also a factual basis for this plea. I'll sentence you to withhold of adjudication and court costs. And also I must remind you and advise you, Mr. Washington, that upon a third conviction for driving with license suspended, it may result in a mandatory 10-day jail sentence pursuant to Florida statute. Do you understand?
Yes, ma'am.
And also may result in a third within 5 years, may result in a 5-year driver's license suspension and you being declared a habitual traffic offender through the DMV. Do you understand?
Yes, ma'am.
There's also another potential that a third arrest for driving with license suspended could result in you being charged with a felony. Do you understand?
Yes, ma'am.
Knowing all that, do you still wish to maintain your no contest plea?
Yes, ma'am.
All right, thank you, sir. How much time does he need to pay, Mr. Barbaric? All right, and I'll give you 1 year to pay court costs, cost of prosecution, PD application fee. Good luck to you, Mr. Washington. If nothing else is holding you, you should be released today.
Yes, ma'am. Thank you.
Of course. Next is Mr. I believe, Bally.
Thank you, ma'am.
Quarantine, so we'll come back to him. All right, thank you. So let's go to North Broward. All right, good morning. This is Mr. Coakley, correct? Sir, you Coakley?
Correct.
All right, good morning, sir. Mr. Linder, this is a motion for 3040. Has the state file charges?
Information has been filed, Judge.
All right, thank you. So Mr. Coakley, at this time, the state has filed an information against you, so your motion for ROR will be denied. Please be in touch with your attorney so that they can let you know the next steps in the proceedings. Is there anything else in his case that we need to address?
No, Judge.
All right, good luck to you, Mr. Coakley. All right, let's go over to Paul Ryan.
Yes, Your Honor.
All right, who do you guys want me to call first?
Hatter, Your Honor.
Hatter, okay, Miss Hatter is on page 5. Just give me 1 minute to get her PCs. right, Ms. Hatter, good morning, ma'am. This is a change of charge. The state has filed an information against you. You were originally charged with leaving the scene of an accident with death. The state has now filed an information charging you with driving under the influence manslaughter, UVAL, and driving under the influence manslaughter impairment. I see that the original bond set on 5/28 this year was $75,000 for the count of leaving the scene of the accident with death. Let me first turn to Mr. Linder.
I spoke to Mr. Weiner this morning. My understanding is these are actually change of charges from the misdemeanor DUI counts. Since her first appearance, the state got the lab results back, or the blood results back, Your Honor. I can advise the court that her blood tested positive for ethanol and THC. One moment, Your Honor. The specific results. One sample was taken at 2:27. The crash was at 10:07 in the evening. One sample was taken at 2:27 in the morning. Her blood alcohol was a 0.166, and there was THC in her system. Another sample was taken at 7:49 in the morning, and her blood alcohol content was 0.086, and still, obviously, there was THC in her system, Your Honor. As I mentioned, I spoke to Mr. Weiner this morning. In addition to the $75,000 bond that the court made reference to, she also has a $10,000 bond on no valid DL causing death, 1,000 on the DUI property damage, and 10,000 on leaving the scene. Additionally, she has multiple no bond holds from Lake County. Your Honor, the state would be seeking a $50,000 bond on each of these counts, with the same release conditions that were set at her original first appearance.
Okay, thank you, Mr. Farber.
Judge, the total amount of bonds without.
You're muted, so she can't hear you. Let me turn this down if you need me to. Go ahead.
Yeah, the total amount of bonds, Judge, without these two is over $96,000. She also has those no bond holds. She's not going to be able to post any bond at this point. I would just ask the court to set the bond as low as possible.
All right, thank you. So, Ms. Hatter, I am going to set your bond on each of the driving under the influence counts with death at $50,000. If you are able to post your bond, ma'am, you are going to be supervised by pretrial release level 1 as originally set by the magistrate judge who you came before on the 28th of May. But you also cannot use any drugs or alcohol while your case is pending. Do you understand? And you are going to be randomly screened for drugs and alcohol while your case is pending, as originally told to you at first appearance. Do you understand?
Yes.
Okay, and was there a minimum amount? I didn't see that.
I'm sorry, Your Honor?
I believe there's been a change in circumstance, Mr. Linder and Mr. Corbett, because I don't believe the court at the time had the blood or the blood results. So I am.
Oh, absolutely. There.
Okay, so I am going to order random screens at a minimum of 2 times per week, because of the change in circumstance. And ma'am, you cannot drive while this case is pending, specifically because you're going to be on house arrest. You understand?
Yes.
And all other previous terms and conditions apply. I believe there was a passport surrender that was also done by the previous judge. Anything else on her case we need to address?
No, Judge.
Select you, ma'am. Oh, that one didn't slide as well. It's very tiny. All right, so who else do we have there? Paul Ryan?
Miller, come on.
All right, good morning, ma'am. What's your name?
Samantha Miller.
Samantha Miller. Okay, this is Miss Miller on the second look docket. Mr. Linder, it's a petty theft. Does the state have an offer?
One moment, Your Honor.
Thank you.
The offers adjudication, time served, no return to the Walmart, 5555 West Atlantic Boulevard in Margate, Your Honor.
Do you know which theft this is?
One moment, Your Honor.
Okay, thank you. While he's looking that up, Mr. Farber, do you know what she wishes to do?
In speaking to her this morning, she indicated that she wanted to resolve the case today, so she would accept the offer.
Okay,
And
thank you so much.
I'm showing prior thefts in 2009 and 2010.
Okay, thank you. All right, ma'am, please raise your right hand for me to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth? Sorry, I can't hear you.
Yes.
All right, thank you. Can you please state your name for the record, and you can put your hand down.
Samantha Miller?
All right, Ms. Miller, it's my understanding you wish to resolve your petty theft charge today, correct?
Yes.
Do you understand the charge against you?
Yes.
Do you understand everything that's happened here today?
Yes, Your Honor.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of alcohol or drugs today, ma'am?
No.
Do you need more time to speak to your attorney?
No.
Do you understand you're giving up your right forever to fight this charge and go to trial by accepting the state's offer?
Yes.
Have you ever been treated for a mental or emotional illness, ma'am?
No.
I'm not asking if you're a citizen. I just have to advise everybody that comes before me for a plea. Do you understand if you're not a United States citizen, by accepting this offer, you shall be subjected to deportation proceedings if you're not a United States citizen?
Yes.
All right, and I also must advise you that this is a third arrest for a theft. If you get any more arrests for petty theft, you may be charged with a felony petty theft or receive jail or prison time if convicted as charged. Do you understand?
Yes.
And knowing all that, Ms. Miller, how do you wish to plead, guilty or no contest?
No contest.
All right, Ms. Miller, I accept your no contest plea. It's freely, knowingly, voluntarily given. I also find there's a factual basis for this plea. I am going to sentence you to an adjudication, time served, no return to the Walmart in the police reports. And how much time does she need to pay, Mr. Farber?
He asking for 1 year.
Not a problem, and I'll give you 1 year to pay those court costs, cost of prosecution, PD application fee, Mr. Miller. Good luck to you. If there's nothing else holding you, you should be released today, ma'am.
Thank you.
No problem. And last but not least is Mr. Jean Baptiste, or Miss Jean Baptiste also. All right, good morning, ma'am. Mr. Linder, this is Miss Jean Baptiste on the second page of the FMN docket. It's a 3040 motion for release.
Information has been filed, Judge.
All right, thank you. So at this time, Ms. Jean Baptiste, the state has filed an information against you, so your motion for ROR will be denied. Please be in touch with your attorney so they'll let you know the next steps in the proceedings. Anything else on her case that we need to address?
Yes, her bond is now $1,000.
Okay, thank you. So it was reduced?
Follow everything.
Oh, okay.
Charge that $1,000.
Okay. Thank you, Ms. Cooper. So Ms. Jean Baptiste, your bond is now $1,000. Only one of the charges with that bond was filed. So now your total bond is $1,000, okay?
Okay.
All right, good luck to you, ma'am. All right, so while we wait for the Spanish interpreter, let me start with my private attorney cases. On page 1, I have Ms. Messier on Ms. Rastetter is here on her behalf.
Sorry, good morning, Your Honor.
Good morning. Just give me 1 minute. Guys, I need the DV contact orders, please. When you get a chance, just switch with me. Thank you so much. That's a good step. All right, good morning, ma'am. All right, good morning, Ms. Messier. I do find probable cause for battery, cause bodily harm, domestic violence. Mr. Linder, I will first turn to you and then Ms. Rastetter.
Your Honor, I believe counsel and I have an agreement if it's acceptable to the court.
Sure.
We've agreed to $1,000 bond, no victim contact. I checked. I did not see any history from Ms. Messier.
That's correct, Your Honor.
All right, thank you so much. All right, ma'am, I am going to set your bond in the amount of $1,000. The conditions of your bond, even while you're in custody, you cannot have any contact with the listed victim, direct or indirect. Do you understand? Yes. That means you cannot live with the listed victim. You cannot call, text, email, social media, send letters, have a family member or friend, or any other means of communication that I have not said with her. Do you understand?
Yes, ma'am.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand?
Yes.
All right, is there anything else on her case that we need to address?
No, Judge.
All right, thank you. Good luck to you, ma'am. Nice to see you, ma'am, Ms. Rastetter.
Thank you.
All right, just give me 1 minute to finish filling these out, and then I'll get to Mr. Davenport is going to be the next case that we handle. Just let me finish filling out this these orders.
Yes, in the court. Okay.
All right, so next is Mr. Davenport on page 25.
Good morning, I'm on point on behalf of Mr. Davenport.
Good morning, Ms. Mompoint. Nice to see you, ma'am.
Hi, Judge.
All right, so Mr. Davenport, good morning. We reset your case yesterday for your attorney to be here, and Ms. Mompoint is here on your behalf. I do find probable cause for, it actually should be attempted murder. It just says murder on the docket. Count 1 is attempted murder in the first degree with premeditation. Count 2 is a burglary of a dwelling armed. And I also make a finding of proof evident, presumption great. And at this time, I am going to hold you no bond. You're going to have to go before your division judge within which to have an Arthur hearing heard. It's the allegations are that you are the alleged shooter. So you'll have to file a motion with your division judge because at this time I'm holding you no bond. You can, the conditions of your custody, sir, or that you cannot have any contact with the listed victim, even while you are in custody, direct or indirect. You understand?
Yes, because of, yes.
All right, that means you cannot call him, you cannot send letters, you cannot have a family member or friend send a message to him or any other means of communication, even while you're in custody. Understood? You also cannot have any co-defendant contact. Do you understand, direct or indirect?
Yes.
All right, and so Mr. Linder, I will need to keep separate order, please.
Yes, Judge.
All right, and if your division judge does release you from custody, sir, you cannot return to the listed victim's home. There will be a no return order in place. Do you understand?
Yes.
And you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand? Okay, is there anything else on his case that we need to address today?
I just wanted to make on the record that it is, so we are able to go forward with an Arthur hearing if necessary.
Yes, absolutely. It is always without prejudice at first appearance so that he has that opportunity to file a motion with his division judge.
Thank you so much, Judge.
Thank you. Nice to see you.
You too.
Thank you. Take care. All right. So do we have any other private attorneys that are in the courtroom? Otherwise, we're going to start on page 1. All right, hearing nothing, let's continue on page 1. We have Ms. Abbasi on page 1.
She is here at main, Judge, approaching.
All right, thank you. Ma'am, good morning. I do find probable cause for touch or strike battery, domestic violence. Mr. Linder, first to you, sir.
Judge, I'm recommending $1,000 bond, no victim contact. While I see no local history, this is based on the allegations in the probable cause affidavit.
Okay, thank you. Mr. Romero, sir.
Judge, I spoke to Ms. Abbasi. She's been residing here in our community for a number of years. As the state advised, she has no prior record. This is the first time she's ever been arrested in her whole entire life. Now, she does live with the alleged victim. I did advise her the significance of a no contact order. She will be abiding by that. Unfortunately, she advised me when she was arrested, she didn't have an opportunity to have her phone with her. She has no numbers memorized, so unfortunately, she has no one to call to post her monetary bond. Based on her lack of criminal prior, Judge, I was going to ask the court to consider releasing her ROR or in the alternative ROR to pretrial.
Based on the level of violence, she's not a candidate for straight ROR. I will release her to pretrial release, but she's going to be randomly screened for alcohol and drugs based on there being the alcohol influence box checked off. Ma'am, you're going to be released today, but you have to call to pretrial release before 11 a.m. tomorrow. So please give your phone number to pretrial before I continue with my orders.
Give them your phone number right now.
305
Louder, please.
905-7852.
Did you get that, Ms. Moore? All right, ma'am, you can use any drugs and you cannot use any alcohol while your case is pending. Do you understand? Based on the level of violence, you're going to be randomly screened at least one time per week while your case is pending. Understood? And you cannot have any contact, direct or indirect, with a listed victim. Do you understand? Sorry, she's very soft-spoken.
He answered in the affirmative, Judge.
All right, thank you. That means that not only can you not live with him, you cannot call him, text him, email, social media, send a family member or friend to send a message to him, or any other means of communication that I have not said. Do you understand?
Yeah.
All right, ma'am. I also cannot, you also cannot, how do I unmove this pin? Okay, you also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yeah.
Okay, and that's based on the domestic violence nature. Does your office need to be provisionally appointed, Mr. Romero?
No, she's going to retain private counsel, Judge.
All right, good luck to you, ma'am. You're going to be released today. You need to call in tomorrow before 11. All right, next is Ms. Poole on page 1.
She's approaching, Judge.
Okay, thank you. All right, Ms. Poole, good morning, ma'am. I do find probable cause for battery, cause bodily harm, domestic violence. Mr. Linder, first to you, sir.
Judge, I'm recommending a $1,000 bond, no victim contact. She has a pending possession of cocaine that I believe and prostitution that I believe Ms. Worrell has some information on.
Okay, my apologies, Ms. Worrell. Yes, ma'am.
Your Honor, the defendant was released for pre-trial standing to provision in case number 20357 CFNA, one count of possession of cocaine. And the second count was offer of the secure act for prostitution. The defendant stopped taking the pre-trial mid-April of this year at this time. Sexual representation of prostitution.
And
That was 2357.
Yes, Your Honor.
Okay, thank you. Mr. Linder, first to you on that request.
yes, Your Honor, I'd ask that you grant a pre-trial's request, set the bond on the possession of cocaine at $1,000, no bond attached on the prostitution. Because additionally, Your Honor, Ms. Poole was arrested last year for aggravated battery with a deadly weapon against the same alleged victim. That was dropped. She was arrested in 2017 for felony battery against a victim over the age of 65. That was dropped. Prostitution 2016, theft 09, resisting without violence 05. Nothing further, Judge.
Thank you, Mr. Romero.
Judge, considering what we just heard, I just spoke to Ms. Poole. At this time, we're just asking to be provisionally appointed. No objection to the $1,000 bond on the new law offense. She does realize the significance of the no contact order. She does not live with the alleged victim. And as far as taking action on the case, no objection to setting a $1,000 bond on the case that she's currently out on supervision.
All right, thank you. So I will grant pre-trial's request and set a $1,000 bond back on the cocaine possession and ROR on the prostitution offense. So that will be revoked. All right, and on the new law, ma'am, $1,000 bond, the conditions of your bond, even while you're in custody, Ms. Poole, you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
I do, ma'am.
All right, that means that not only can you not live with him, you cannot call him, text him, email, social media, have a family member or friend send a message to him, or any other means of communications that I have not said. Do you understand?
Yes, ma'am.
All right, does your office need to be provisionally appointed, Mr. Romero?
Yes, Judge.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you will need to reapply if this case is still pending. Anything else on her case?
No, Judge.
All right, good luck to you, Ms. Poole.
Here's the phone number of the PD. Call it, contact your assigned attorney.
All right, next is Ms. Hamlet on page 1.
Come on up, Ms. Hamlet. She's here present.
Thank you, Ms. Hamlet. Good morning, ma'am. I do find probable cause for touch or strike battery, domestic violence. Mr. Linder, first to you.
Your Honor, I see no history. I'm recommending an ROR to pretrial, no victim contact.
Okay, thank you, Mr. Romero.
Judge, that's exactly what we're going to be asking for.
All right, thank you. Ms. Hamlet, you're going to be released, trial release. That means that you're going to get out today, but you have to call in tomorrow before 11 a.m. So please provide your phone number to pretrial before I continue with my orders.
954-683-3849.
All right, Ms. Hamlet, the conditions of your pretrial release, ma'am, are that you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes, ma'am.
That means that not only can you not live with him, you cannot call him, text him, email, social media, have a family member or friend send a message to him, or any other means of communications I have not said. Do you understand?
Yes, Your Honor.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on a domestic violence nature. Do you understand?
Your Honor.
And does your office need to be appointed?
Yes, Judge.
All right, thank you. And I will also provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you will need to reapply if this case is still pending, okay?
Yes, ma'am.
Good luck,
Thank you.
Hamlet. Please call in tomorrow.
Before 11 a.m. Okay, good luck, ma'am.
Next is Ms. Stanley on page 2.
He's approaching, Judge, here, Maine.
All right, thank you, Ms. Stanley. Good morning, ma'am. I do find probable cause. It's backwards for some reason. Count 1 is false imprisonment of an adult. Count 2 is aggravated battery. Offender knew or should have known victim was pregnant. Count 3 is burglary with an assault or battery. I do make a finding of proof evident presumption great, but I do so without prejudice. Let me hear from you first, Mr. Linder.
Your Honor, I did speak with Ms. Donaldson, the alleged victim, this morning. She would like the court to issue a no contact order, but she does not have an objection to the court setting bonds. I'm going to be recommending a $2,500 bond on the false imprisonment, a $5,000 bond on the battery on the pregnant victim, and $7,500 bond on the burglary with the battery, for a total bond of $15,000 with an order of no victim contact. The only prior I saw, Your Honor, was a 2006, I'm sorry, she had 2006 grand theft, a 2006 petty theft. Nothing further, Judge.
All right, thank you, Mr. Romero.
Judge, I spoke to Ms. Stanley. Even though the state has no objection as far as setting monetary bond, I'm going to be also asking the court to exercise its discretion and impose a monetary bond and not impose a no bond hold on count one. In speaking to Ms. Stanley, she's been residing in our community her whole entire life. She does not work. She gets disability, so she is on a fixed income. She receives approximately $700 a month. She lives separate and apart from the alleged victim. She understands and will be abiding by the court's order as far as no contact, direct or indirect. Now, she is a single mother. She resides in Coral Springs, where she rents an apartment. As you heard, Judge, she does not have significant contact with the criminal justice system. She is not, from my understanding, she is not a convicted felon. I believe the only contact with the system she had was around when she was around 18 years old. Judge, she's not going to be able to afford what the state has asked for, I believe a total $15,000 bond. What we are going to be asking for is a total of $5,000 bond. We understand the seriousness of the allegations, and based on the seriousness, we wouldn't object also if the court wanted to impose an added layer of security as supervision and have Ms. Stanley supervised, but she cannot afford a $15,000 bond at this time, and I'm going to be asking to be provisionally appointed.
All right, thank you. Based on this being a life felony, if convicted as charged, I find the state's request to be very reasonable. But however, I am going to put her on a level 2 monitor because again, she is facing life in prison if convicted as charged. Based on these allegations, she allegedly punched the listed victim multiple times in her stomach, knowing she was pregnant. So I am going to set bond as requested by the state because the listed victim has advised the state that she is okay. And this is only because the listed victim has advised the state that she is okay with the court setting bond. Otherwise, she would have been held no bond. So on count one, bond's going to be set in the amount of $2,500. Count two, $5,000. Count three, $7,500. If she's able to post that bond, pretrial release level 2 with the GPS for the records I put forth on the record, the reasons. And ma'am, if you do post bond, you cannot return to the listed victim's home. Do you understand?
Yes, I was never at her home.
We'll talk about the facts of the case, ma'am. Do you understand? Don't return to the incident location. Do you understand?
Yes.
If you have any contact, direct or indirect, with the listed victim, that means that not only can you not go by where she's living, you cannot go by where she's working, or if she's going to school or the doctor's appointments. You cannot call her, text her, email, social media, letters, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
She answered in the affirmative, Judge.
You also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Ms. Stanley. Once COVID is over, you will need to reapply to make sure that they keep representing you. I have in their contact. Okay, thank you. Anything else on her case?
No, Judge.
And you said 2,500, 5,000, 7,500?
Yes, ma'am. They were just recapping the bonds. Good luck to you, ma'am. All right, next is Ms. Linda on page 3.
I'm sorry, Your Honor.
Thank you, Ms. Lind. Good morning, ma'am. I do find probable cause for battery on a person 65 years or older, 2 counts. Mr. Linder, first to you.
Just one moment, Your Honor. My office had contact with the alleged victims yesterday. I just wanted to pull that email so I can see what information they relayed to us. Okay. Your Honor, both of the alleged victims advised that they want Ms. Lynn to get treatment at a long-term facility. They advised that she's had several hospital stays. They want no contact. They did advise of mental health issues, Your Honor. I'm not going to go into any specific diagnosis they mentioned for Ms. Lynn's privacy. Your Honor, I can also advise the court that while I know it doesn't state it in the PC, I can mention as an officer of the court, the alleged victims in this case are 82 and 86 years old. The way I know this is Ms. Lynn was arrested earlier this year for battery, 2 counts of battery against a victim over the age of 65 and tampering with a witness or victim. It was the same alleged victims in that case. I pulled the probable cause, the sworn probable cause affidavit from that case, which listed both victims' dates of birth. Additionally, Your Honor, Ms. Lynn was arrested in 2016 for a felony battery against a victim over the age of 65 and misdemeanor battery. Listed the alleged victim in that case was her father, who's one of the listed victims in this case. Those charges were dropped. She did plead out to a reckless driving with priors in 2016 felony case. Judge, based on her previous arrest and one as recently as this year against both alleged victims and the vulnerability that these victims have based on their age, I'm recommending a $5,000 bond on each count and no victim contact.
Did you say the case earlier this year was dropped?
Yes, it was dropped March 18th, Your Honor.
Okay, thank you. Mr. Barbaric?
Judge, I can tell the court that she's lived here for approximately 10 years, that she does have some money to post bond. I would ask for the court to set up basically $1,000 or $1,500 with regards to each count.
All right, thank you. Does your office need to be provisionally appointed?
We would be for now, Judge.
Okay, thank you. All right, so I am going to unmute her now, but Ms. Lind, just listen very closely, okay? I am setting your bond in the amount of $5,000 per count. The conditions of your bond, ma'am, even while you're in custody, you cannot have any contact with either of the listed victims, your parents. Do you understand?
Oh, this is for my mother and father, Murray and Harold Lynn?
It is for both of your parents, correct? Mother and
Very
father
good.
cannot have any contact with either of them, direct or indirect. Understood?
Yes.
All right, also that means that not only can you not live with them, meaning you cannot return to the listed property, you cannot call them, text them. Mr. Barbaric, I muted you because it's the echo.
Okay.
Okay, thank you. You cannot call them, text them, email, social media, send letters, have a family member or friend send a message to them or any other means of communication that I have not said. Understood?
Yes.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Understood?
I don't know any of that.
All right, not a problem. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic.
My general counsel, John Menzel, will be my attorney.
Okay, so whenever he does file in, he'll be a substitution of counsel, but he needs to file a notice of appearance. So
Okay.
until that happens, I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. And once COVID is over, you'll need to reapply if that attorney has not filed in, and you need to continue to need the services. Okay.
When is COVID over?
I'm sorry, ma'am.
I was vaccinated, but I'm not understanding when you're saying when COVID's over. What do you mean by that?
When we're no longer in a state of emergency.
Oh, we're in a state of emergency in the state of Florida?
We have been since March 2020. Good luck to you, ma'am. All right, next is Miss Woolley on page 4.
Here, President Judge Jermaine.
All right, thank you, Miss Woolley. Good morning, ma'am. I do find probable cause for a violation of an injunction. The allegations are that she was allegedly at the victim's home at 3:38 a.m. in the morning. Mr. Linder, any priors in the state's recommendation?
Your Honor, this is actually a violation of a no contact order from a pending felony battery due to priors.
I need that case number, please.
19-14081 CF10A. It does involve this, obviously it does involve the same alleged victim.
So it's both. Okay, give me 1 minute.
Sure.
All right, Ms. Woolley, on January 9th of 2020, you were advised to not have any contact, direct or indirect, with the listed victim, I am going to revoke your bond in 19-014-081 CF10A because you have violated the conditions of the court's no contact order by being at the victim's home at 3:38 in the morning. You're going to be held no bond on that case. On the new law, I am setting bond in the amount of $10,000. If you're able to post bond, you're going to be on pretrial release level 1 with a GPS strict house lockdown. Again, no contact, Ms. Woolley, means that you cannot call, you cannot text, no emails, social media, letters, pigeon carriers, messages in a bottle, any other means of communications that I have not said. Do you understand?
Yes, ma'am.
You also cannot be at or near the victim's home. Do you understand?
Ma'am, can I say something in regards to
No,
that?
ma'am, you cannot talk about the facts of your case because anything you say is being recorded and can and will be used against you. Do you understand?
Yes, ma'am.
You also cannot possess any firearms, weapons, ammunition while your case is pending based on the domestic violence nature. Do you understand?
Yes, ma'am. We're here.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic based on the court's no bond hold. Once COVID is over, you'll need to reapply to make sure they keep representing you. Good luck to you, Ms. Woolley.
Judge, if I may, I still have to make my record, and I have to, and speak Ms. Woolley. My understanding is, yes, she is aware that she's here on an injunction. We did talk about that. But unfortunately, as you see, she's been out on that case since 2019. It was at the request of the victim that she returned to the home. They share children in common, and Ms. Woolley was the person taking care of her children. Now, she's been residing here her whole entire life. She has a mother that resides here in the county that she can live separate and apart. Rather than, I know the court is taking action, but rather than holding her no bond, which is the most severe sanction this court can impose, I'd ask the court to consider a level 1 pretrial house arrest so that she could reside with her mother and impose level 1 on the new law offense as well. And I'll be asking to be provisionally appointed, Judge.
All right, thank you. I understand your request. I've ruled. Good luck to you, ma'am. Is there a domestic violence no contact for this Woolley case? I don't have one here. Please prepare one for me so that it's very clear. Okay. Thank you.